Start para. The appellants are the original plaintiffs in special case number 145/2001. They had filed suit for account and realization of money against the defendants. The learned trial court had dismissed their suit on 30/4/2015, being aggrieved by the dismissal of their suit by the learned civil judge (Junior Division) Ballarpur. The appellants have preferred this appeal and challenge the judgment and decree of the trial court. The parties are referred as per their status in the trial court. Para. The plaintiff number 1 is the legally wedded wife of one Dinkar. This Dinkar worked as primary school teacher, and in due course he was promoted as headmaster of primary school of Municipal Council Ballarpur. He died on 26/11/1998 while in service. The plaintiffs state that the marriage of plaintiff number 1 and Dinkar was in existence till his death. Their marriage was never put to end by either of the parties. Further, she stated that both the parties being Hindus, their marriage could not have been dissolved without a decree of divorce from the court. She stated that Dinkar had filed a Hindu marriage petition number 29/1976 for divorce against her, but this petition was dismissed on 25/8/1983. This Dinkar had filed an appeal number 154/1983 in the District Court Chandrapur, but his appeal was dismissed on 31/12/1991. Thus, their marriage was in existence and never dissolved. The appellant number 2 is the son of appellant number 1 and Dinkar from their wedlock. They state that the disputes between the parties and the dismissal of Hindu marriage petition number 25/1976 was known to the municipal council, and the copy of judgment was submitted to them. The appellants state that as Dinkar died while in service, he was entitled to pension, gratuity, provident fund, and balance salary, etc. The appellant number 1 did not have the knowledge about the monthly salary of Dinkar. She did not know what amounts were due to him from his gratuity, provident fund, pensionary benefits, and the balance salary, etc. She had issued a notice on 5/12/1999 and 10/5/2000 and sought the information from the respondents. In spite of notice and repeated personal visits, the respondents did not furnish required information to her. Para. The appellants state that Dinkar had married another lady, Suhasini. They state that he could not have legally married Suhasini unless their marriage was legally divorced. They state that the marriage of appellant number 1 and Dinkar was in existence and he could not have married this lady. They state that this lady, Suhasini, cannot claim any right as a widow. They state that this fact was brought to the notice of respondents, but even though in collusion with each other, they made all the payments of the pensionary benefits to this Suhasini, even when she was not entitled for it. The appellants state that they were not aware about the pension amount, and so they paid court fees on an amount of rupees 1,10,000. Lastly, the plaintiffs prayed that the respondents be directed to render the account of payment of money made to Suhasini after the death of Dinkar. They also prayed that the respondents be directed to pay the money to them with interest. Upon the suit, the summons were issued to the respondents. The defendants appeared through their advocates and filed their written statement at Exhibit 21. They have denied the contents of the suit. They denied that the appellant number 1 is entitled for any relief as prayed for. Stop.